We have talked of who may petition for winding up: the company, the creditors, those are voluntary. Then we talk of any contributory. And a contributory, as we have seen in the Act, is a person liable to contribute to the assets of the company in the event of its assets being wound up. And a contributory can't petition if the statutory numbers are below minimum, the 7 and the 2. So that contributory is not allowed to interfere once the court and the registrar have realized that the statutory members are not up to the requirements. And where this contributory, the shares concerned, those that he has, they were allotted to him at least 6 months within the period of 18 months before the commencement of the winding up, he cannot petition. Where that period, 18 months, and if today, counting the 18 months from now is when a resolution is passed on the winding up, and you realize your shares are within that period, then you as a contributory cannot petition. The AG may petition for winding up, again based on the inspector's report. And the inspector's report is where we'll find mismanagement, conducting illegal businesses. And section 172 is where it provides if the court feels in its exercise of powers and its discretion, it's in the public interest that the company be wound up, it will continue to do so. The reason we say the public interest, you see, for a public company, once it trades, we talk of even future members, those who may be tempted to look at the performance in the past in order to buy shares. We talk of creditors, again in the public interest. If the investigator realizes that things have been covered, which if put to light would have changed people's opinions, I would not have bought shares of this company had I known that the management was misrepresenting the profits or misstating the profits, making them look higher than what they originally should have been. So where the investigation has been done, an inspector's report is attached, and it is seen that for the public good, for the greater good, the company should be wound up, then the AG will petition for the winding up of this company. We also have by the official receiver under section 231. And while a petition may be presented to the court, whether it's voluntary or subject to the supervision of the court, the court, again, section 231 will give us the discretion of the court. We will discuss who an official receiver is, what his powers are, but these are the people who can petition for the winding up of a company. We have talked about the winding up voluntary by members, by creditors, compulsory by the court, where we said if the registrar sees that the statutory requirements are not met. And now we talk about, remember we had said the winding up we also have the supervisory winding up, which is what we are talking about. And it is covered under section 303 of the Act. It starts up as a voluntary winding up, and a liquidator or a creditor may apply to the court requesting that the winding up be proceeded further and at the supervision of the court. And it's at the discretion of the court, because it could be an issue of the creditors are not okay with how the members are doing it. They feel maybe the members are too slow, or the members are acting preferentially towards one creditor instead of the next. And these are matters to be proven in a court of law. And section 304 provides that when a company has passed a resolution for voluntary winding up, the court may make an order that the voluntary winding up shall continue, but subject to supervision of the court, and with such liberty for creditors, contributors, or others to apply to the court as the court may think just, on such terms and conditions that may be specified by the court. So supervisory winding up is where the winding up may have started as voluntary, either by the members or the creditors, but one of the parties, you see, we have different parties. We have different interested parties in these winding up procedures. We have the shareholders on this hand. We have the creditors on the other hand. Each is waiting to see what are the benefits of this winding up. Am I able to recover some amount that I spent? Am I able to, are the debts able to be paid off? And once they are paid off, will we be called upon to cover any more debt than was catered for? So the court, in its discretion, once any party presents that these winding up procedures are not being followed, or they're favoring one party against the other, it will order onto how that winding up will be done. And we have the general provisions that relate to winding up. And when we say, when the order or resolution is passed, then winding up commences. And the timing is important, because it is from the date of the commencement of the winding up that the process of liquidation is deemed to have started. Liquidation is the assets are identified and they're sold off to pay off the debts. So that resolution, once it is passed and registered with the registrar is made aware and there's no objection. That time factor is important, because remember, once we commence winding up, the liquidator takes over the role of the directors, board of directors, their powers cease. Liquidator steps in and starts finalizing, because trading comes to a stop. And the only essence is to pay off debts, to ensure that all the obligations are met. And there must be a notice of commencement of the liquidation. This is through the Kenya Gazette or through a daily that is widely distributed and widely acceptable, widely accessible as well. So not only does the winding up commence, that notice must be given out. And it is again to protect the members of the public. It is to protect the general, the company itself. Because once you realize winding up proceedings have been done, a liquidator has been appointed, then trading basically stops. So it protects a creditor from doing business with this company. And once a liquidator is appointed, we have seen what he does. bring the creditors up to speed, bring the affairs of the company, finalize this distribution of the assets. And this is where we are saying notice is very important, and why it has to be in the Kenya Gazette or a daily that is distributed, reaches a wider population, because once liquidation commences, certain activities of the company ceases. Legal action by or against the company, disposition of the company property, and the court will be involved in these matters, which is where we are saying, should any category feel their needs are not being met, then they petition to the court to supervise this winding up. So once the winding up proceedings have been made, notice must be given so that no one can purport to sue the company, and the company cannot purport to sue an individual. It cannot purport to buy anymore because its activities are coming to a halt. And the reason why in that meeting, the creditors will be told, this is what we are purposing to do, they must prove their debts. So that once the liquidator is able to assess how much can be received from disposing of ABCD, then the creditors will then be paid. The final meeting is very key because once the winding up is done, the affairs have been done, dissolution immediately commences. And dissolution can only be challenged on appeal in the Court of Appeal. And a company can be restated if the dissolution was void according to Section 270. Remember, in the Companies Act, as we saw, we talked about the original jurisdiction. It is the High Court. When in the introduction to law and governance, we talked about the court structure. So for the High Court, the next court is the Court of Appeal. And that is where the winding up process was not done as it should have been. And the High Court erred in either judgment or fact. They petitioned to the Court of Appeal. And the Court of Appeal, once they hear the case, they can decide that the company can be reinstated if, according to Section 270, and this is what we are saying, that subject to such conditions and limitations as may be prescribed by the rules, an appeal shall lie to the Court of Appeal from any decision or order given or made by the High Court in the exercise of the jurisdiction conferred upon it by Section 218. So the court decides, do we reinstate, do we uphold? And the rules of the decision of the court will be maintained.